Hey everybody, how's it going? And welcome back to Copper Jacket TV. So today I've got some good news for you. There was a 10-year stretch where the Supreme Court just was absolutely not taking on Second Amendment cases. We send plenty up there, but they just sent all of them back down to the lower courts. Well, it looks like that's finally changed, and the Supreme Court has taken up another 2A case. This one is U.S. v. Rahimi. Let's talk about what's going on. This channel is proud to be sponsored by the USCCA. Listen, if you carry for your own defense and you don't have a lawyer, you don't have an attorney, or maybe you just don't have the money in the bank to defend yourself, you need a USCCA membership. With your membership, you get that self-defense liability insurance. You get a lot of other resources that you're going to find online, a lot of training and tips that are going to help you while you're out there, and SDI. If you guys have ever wanted to get into, let's say, gunsmithing or armory classes, you want to know a little bit more about that, check out the link down below to SDI. It's a phenomenal place to learn and really take your hobby to the next level. Okay, so US v. Rahimi is a very interesting case, but I'll try and keep this short and simple. It will have a huge effect on a lot of people across the country if it's found to be unconstitutional, but basically what it's challenging is the prohibition of firearms ownership and possession by those who are under a domestic violence restraining order or have been convicted of misdemeanor domestic violence. So I'm sure there's some people out there that are saying, good, these people should be prohibited. But you have to remember that in a lot of states across this country, when it comes to getting one of those restraining orders, very little to no proof is actually required. What's required is just a simple statement from somebody, an accusation, or maybe a sworn affidavit, something to that effect. But when it comes to evidence, little or no evidence is required in order to get one of these. It just, again, has to be somebody's statement. And so you're talking about taking somebody's constitutionally protected rights away from them just based on the statement of somebody else. And it could be a completely unsubstantiated statement, and boom, your Second Amendment rights are gone just like that. Okay, so what about those people that have been convicted? Well, this is really important. You have to remember that, again, in a lot of states, the way that the law is carried out is going to be different. And so a simple nudge could get you into hot water. I'm serious. A simple nudge could be considered battery. That could get you into a lot of trouble. And so people that have been convicted of these things could be convicted for varying degrees of reasons. Now, I am not condoning it in any way, shape, or form. I'm simply just pointing out the obvious. There's some people out there who just have that partner that just wants to get them in trouble, and they'll find a way to get you in trouble, and they know that you're into this type of stuff. Well, they're going to want to try and take that away from you, and, well, they'll use whatever means necessary. And so sometimes that comes into play. And you have to consider that when it comes to these types of cases, especially when it comes to misdemeanor cases. Things aren't always applied equally. And so you have people who are having 10-year plus prohibitions, I mean, even lifetime prohibitions, because of something as simple as a sworn affidavit or a comment or a nudge. I mean, just as simple as that, boom, you've lost your rights. So here's where I think this case actually faces some problems, right? So post-Bruin, you have to look back and you have to find some type of historical analog to compare it to. And if there's a history and tradition of that type of regulation, then that type of regulation could stand today. And what the state is going to try and do here is they're going to try and say that throughout history, and it's true, throughout history, people who are convicted of certain crimes lose their ability to have some of their rights. And that is the case for a lot of different things, not just the Second Amendment. But as we look through in time, we can see that from 1791 to the Reconstruction era, during that period, people have lost their rights because of certain convictions. And they'll say, well, maybe they can't find something that has to do with this specific type of conviction, but it does uphold the fact that there is some type of historical analog that says certain crimes can force you to lose your rights. And so that's where the state's going to go. There's going to be a lot of historical analog they're going to point to, and they're going to try and reference that, even if it's not exactly the same thing. So not this specific type of incident, but they can point to something and say that law and conviction dictate whether or not somebody maintains their rights or not, like felony convictions, for instance. Now, this is going to be a really interesting case to watch, and let me tell you guys why. So this is the first case since the Supreme Court gave guidance to the lower courts on how they should look at Second Amendment cases with text, history, and tradition and not the two-step approach that the Supreme Court is actually hearing. And in my opinion, this one's not as cut and dry as a lot that are out there. So a lot of the cases that we're trying to get up to the Supreme Court right now for review, I think are cut and dry. They're very clear. There's no historical analog. A lot of the bans that are out there are clearly unconstitutional and violate people's Second Amendment rights, and they should be overturned by the Supreme Court. This one, however, I want to see how the justices react when the state decides to take evidence of other types of crimes from 1791 to 1868 and say, hey, look, people lost their rights over these. I know it's not the exact same thing. It's not the exact same law, but people lost their rights over that. And so that's going to be our historical analog to say that this law should stand today. I want to know if the justices will accept something that is just simply maybe mildly relevant rather than exactly the same. Because if they choose to take something that is just, like I said, mildly relevant, then what's going to change them from saying that, well, let's say Dirks were banned in, 1796, 1810. I mean, who knows, right? Let's just say that they were banned within city limits or something like that. And the state uses an argument saying, hey, look, these types of things were banned in an entire city and making the entire city a sensitive place. And that's our historical analog. If they take something that is just kind of mildly similar and they apply it, then, we could be in a little bit more trouble than I expected. So I'm really curious to see where this one goes. And I want to see, again, how the judges react to the evidence that's shown within historical analogs. So I wanted to share that with you guys today. It's awesome that the Supreme Court is finally deciding to take on these 2A cases, and we'll see what happens in this one. But again, I think it's going to be an uphill battle for both sides. So it should be something definitely to watch. Thank you all again very much for watching. Please like, subscribe. You guys have a great day.